The content of the following program, including all statements from the hosts and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by the host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program shall not be viewed as substitute for a personal consultation with an attorney. Now, prepare yourself to be informed and entertained by Gus Bravo and Neil Kotze, two AV-rated trial lawyers who have been practicing law for a combined total of nearly 40 years. For the next 30 minutes, they will share their insight and commentary on important legal issues affecting all of us.
Two lawyers go deer hunting. And while they're deer hunting, they stop at a set of tracks. And one lawyer looks to the other and says, "Aha, deer tracks. I recognize them instantly. If we follow these tracks, we're going to get our deer today." And the other lawyer looks at him and says, No. Those aren't deer tracks. Those are elk tracks. Elks are out of season. If we follow those tracks, we're going to waste our entire day. And they debate. Deer tracks, elk tracks, deer tracks, elk tracks. And they're still arguing when the train hits them. Welcome to Attorney Confidential. I'm sorry. That one was all. You had to think about that one. Welcome to Attorney Confidential. I'm Neil Kotze.
And I'm Gus Bravo. That took me a little while. Sorry, I'm a little slow here. Today's Memorial Day, so actually that was funny.
Yeah, that was one of those.
I'm going to laugh on the way home.
That's one of those you have to think about.
Yes. Welcome to Attorney Confidential with Gus and Neil. Again, today's Memorial Day, so we want to obviously honor the veterans, and I always get Memorial Day and Veterans Day confused. I think Memorial Day is we honor obviously the fallen heroes, and right. Veterans Day we honor all the vets. Special recognition, my brother Eric, who's actually serving in the Army. He's out in Oklahoma. Eric, I'm sure you're watching, so happy Memorial Day.
Yeah, and it really, that is exactly the right. We had a great presentation from Captain Michael Shepard, who is a Miami Shores resident who comes to Miami Shores to do our Memorial Day ceremony for several of the last few years. He didn't come the last two because he actually was in combat, but this was his first year back after 3, and it's a very inspirational speech about remembering our fallen soldiers, and not only remembering the fallen soldiers, but their families.
Absolutely.
Because they're the ones right now that have to live with that and they need the support. And our disabled vets, too, who come home, but come home very, very hurt and need our support
absolutely,
as well.
Absolutely. And obviously today being a holiday, I'm a little dressed for the occasion. Neil, you put on a obviously long dress shirt for the occasion. I'm sure you came straight from the office for today.
Raced up the highway from Miami Shores to get here in time.
Anyways, last week we sort of talked about a lot of nothing. And so I think this week
I think I referred to it as a Seinfeld episode last week, but
I don't think you were being complimentary.
No, it wasn't.
So this week I think we wanted to get a little bit more meat on the bones, and we were trying to think about what topic, what sort of ideas we can come up with. And I mentioned to you earlier, I was reading an article on CNN, I think it was, about Bill Cosby, and how I guess recently there was actually a lawsuit that was filed against Bill Cosby. Finally, some would say, but this was creative. This was one of the accusers came out and obviously alleged, I think she was a model, alleged that she had been obviously molested and raped by Bill Cosby, and his lawyer basically called her a liar. I think not only in public and television, and I think wrote something, and so they have now sued Cosby for defamation, which I think is creative because a lot of the other cases were barred by the statute of limitations. So that got us thinking a little bit of, well, the lawyers made an oops moment here because he mishandled the case publicly. And I think in Cosby's scenario, the court of public opinion is completely against him. He may not face any charges in the court of law, but the court of public opinion, he is already lost, and his lawyers are not really helping him. So that got us thinking a little bit about court of public opinion versus a court of law, which is our topic today. I know, Neil, you got a lot of information on that.
Well, yeah, I mean, we've talked in the past about some of the clients I've had the joy of representing a trial.
Emphasis on joy.
where I think you differentiate between the court of law and the court of public opinion.
Right.
I obviously tried a lot of cases for R.J. Reynolds Tobacco Company, and you would probably argue
one time I'm going to let you name drop.
Right. Then I can't name drop the trial for AIG. Right after the big fiasco with insurance, we had a case for AIG who was denying hurricane damage coverage for a hotel chain in Daytona. That one did not fare well in the court of public opinion, but did fare well in the court of law. And the tobacco cases. I mean, the industry prior to recently has really had a pretty high success rate until they lost a major member of their trial team.
Right, and I think what the emphasis.
I was waiting to see if you picked up.
I'm not sure who that member could be.
Right.
But, I think the idea is as lawyers, you have to be sensitive to, it's not just the 6 or 12 people and the judge who you're going to be trying your case in front of.
Well, except for the fact that the 6 or 12 people come from that court. Eventually, they come from a larger element of society.
Theoretically, during voir dire, they claim they've never heard anything about it, but we all know that that's not true. Everyone tries and convicts and passes judgment on these cases, especially the high-profile cases, long before the opening statements. And so, but it's not just really the high-profile cases, right? I mean, I think we were talking about earlier that it's also even just the regular run-of-the-mill cases that you want to test a little bit of your theme to see how the average Joe, the average person, perceives the case. Because again, you don't know until you actually try the case how people are going to perceive it, but you can get a good sampling to see how the general public is going to feel about your set of facts.
Right. I mean, well, that's why a lot of us do either the focus group research or even mock jury trials to mock jurors before we try our cases. There are lots of that goes on now. I mean, some of the tobacco cases, we would try 3 or 4 times to test our themes. The AIG as well, because the big corporate clients are going to pay for that. Because even though those exercises can run themselves, they're going to be not much less than 5 to 10,000, and sometimes as much as 30, 40, 50, depending on what type of jury pool you're putting together.
So, speaking of tobacco, I know that there's a recent tobacco case that's very near and dear to your heart.
Right. I mean, with the appellate court,
and you didn't get this information from Wikipedia this time.
No, this time, Gus called me on Wikipedia. Actually, went and got the official court opinion in the United States Department of Justice versus Philip Morris decision. This was a case actually was tried back in 2006. This tells you how slow the wheels of justice can turn when you're dealing with appellate processes. The trial was 2006. We're still getting appellate opinions coming out in 2015. As we say, the wheels of justice turn slowly. We just want to make sure they don't run over our clients.
And for those of you keeping score, he said that in episode 3, I think.
Do you really remember the episode?
Wow. I'm going to say 3 or 4.
Hopefully we stay around long enough where we won't be able to remember episode numbers.
So tell us a little bit about this case.
Well, the RICO case, I was actually unfortunate to be a member of this trial team to helping the trial lawyers with various issues. It was a very long trial in Washington, D.C. before Judge Gladys Kessler. I remember it well. The industry got pretty well hammered by the Department of Justice. It was a very meticulous case in which, at the end of the day, Judge Kessler issued numerous findings against the tobacco industry, requiring them to make corrective statements on the record, in their advertisements, on their web pages, on the cigarette packaging, about various warnings that weren't being done, various admissions about nicotine addiction, etc. And the way the process works is the industry appeals that. Then the appellate court tells Judge Kessler she did a few things right, a few things wrong. They send it back to her. Then she follows what she believes is the appellate opinion. Then the industry appeals that again, and now we're up on the second round of appeals, which is why...
What kind of warnings?
Well, I mean, what happened was Judge Kessler, and I don't have these committed to memory, it's been so long, but in front of every advertisement, she'd have them do a preamble. And the preamble would read, and I'll use the one for adverse health effects. A federal court has ruled that the tobacco industry has deliberately deceived the American public about the health effects of smoking and has ordered those companies to make this statement, here is the truth.
And as you say that, I think we have a picture that's I think very apropos for this this area. If we don't mind putting up the picture on the tobacco industry.
I don't see these in advance, so I can only imagine what Gus has done here. Let's see.
Well, while we're waiting, Bueller, there's a picture of the tobacco industry that I found online, but I think it will remind you. Remember the pictures you had on your wall? Oh, here we go. So this picture, for those of you keeping score online, it says 20,679 physicians say Luckies are less irritating. It's toasted.
Right. It's like those of you that are a little younger remember the Dentine gum. 3 out of 4 dentists chew Dentine or whatever. Well, when you're my age or a little bit older, you'll remember the 3 out of 4 doctors smoke Camels.
Now this one says at the bottom. You see at the bottom says your throat protection against irritation, against cough.
Yeah. Well, because it doesn't cause anything worse than irritation or cough. That's all you have to worry about. Certainly the message that was being sent.
What picture frames did you have in your wall?
I have the 3 out of 4 doctors. I have an ad that came out in and all the ads I have were actually used at trial against me. But the ad with the little girl sitting in the chair at the doctor's office saying, I hope I get to grow to be 100 years old like you, doctor. And the doctor saying, yes, I hope to be 100 too. That's why I smoke Camels. So anyway, yes, that was back when. Now it's funny because we've gone so many years without advertising at all. It's hard for people to even imagine those ads, let alone any ads, really. But what
kind of warnings here?
Well, what happened was the judge did overstep her bounds, and all kidding aside, with the tobacco industry, they had such a hard-fought battle in the court of public opinion that many times I don't think they were treated fairly in court. There were times legitimately under the law, I think decisions were made the wrong way. And I'm not going to openly criticize Judge Kessler, but people listening to me might get my drift. The issue
earlier, I don't know, if you play back the tape, Judge Kessler, he said, I think the judge overstepped her bounds.
Well, and so did the Court of Appeals. So there I'm just quoting the Court of Appeals. But what happens is RICO is designed to prevent future violations of the Act, future misleading
and
statements.
And for the 5 people listening, can you
RICO,
explain?
racketeering.
Oh, I put you on the spot.
You did put me
You'll come back to us on that one.
We'll come back to me in a second. Corrupt Organizations Act. RICO was originally designed for the mob. Which again, people might say is apropos to use against the tobacco industry. But what happened is that the statute's designed to prevent future harm, prevent you from committing future falsities. So the warning that she required the industry to admit that it in the past had deliberately deceived the public went above and beyond the requirements of the statute.
This was a warning that was supposed to go on the actual product itself?
Yes. The
So
product,
in
the
addition
website,
to the Surgeon General's warning,
oh yeah, it has to go on there. Any ads they do, because the industry can still advertise in certain mediums through the web.
Right.
Had to go on public statements made by the industry, their websites, and they actually were compelled to put this on the packaging. And the court said she went a little bit too far there. But the industry also appealed that the statement she required them to make that they intentionally make their product addictive. That, the court said, although it goes to their motive, it can prevent future harm because people need to understand that it's an intentional act which will help them maybe decide not to smoke. So there the court differentiated between the two statements, which I thought was kind of interesting.
that is creative. So the court of public opinion, obviously, against the tobacco industry, your comment earlier was,
Well, yeah,
it served to really, I think, undermine the way they're treated in the court of law.
In some ways.
What do you mean
I
by
think
that?
this, well, you look at the cases, a lot of the tobacco industry lawsuits are won for reasons different than what the public would perceive. The public would say if someone smokes 3 packs a day for 40 years and gets lung cancer, end of story. They should have a case against the tobacco industry. But what would happen when we tried a lot of these cases, we'd actually dive into the medical records, for example, and some of these people didn't have lung cancer.
Right.
They actually had a kidney cancer that metastasized. And for those, I don't want to get into too much medicine, but it means the cancer actually started somewhere other than the lung and worked its way to the lung. And it started in an organ that is, the cancer is not caused by smoking. So there were instances in cases like that where the industry really did have legitimate defenses, and we won those cases many a time. So the court of public opinion is you should lose every one of them. But when you really dive into the court of law, evidence comes in and explains why maybe this is a case that the industry really truly isn't liable for that person.
I'm just having a hard time crying over spilled milk for the tobacco industry.
I didn't say I was crying.
I don't think that you're making the compelling argument for the court of. I think the court of public opinion is there, and I think that's something an uphill battle the tobacco industry is going to have to endure. So, look, we've come to the halfway point of our show. I think it's a good time for a breaking point. Thus far, we've been talking about the court of public opinion as it relates to the tobacco industry. Second half of the show, we'll get into maybe some other cases.
Absolutely. If anybody wants to call us after the break at 888-565-1470, I can reveal certain secrets, others I can't.
You're listening to Attorney Confidential with Gus and Neil.
Attorney Confidential with Gus and Neil is being brought to you by the law offices of Neil D. Codsey and Bravo Law. Bravo Law is a business litigation firm known for providing common sense solutions to small businesses and individuals throughout South Florida. Mr. Bravo is rated AV by Martindale-Hubbell and Superb by AVBO, the highest ratings available from these two entities. The law offices of Neil D. Codsey is a litigation boutique with offices in Broward and Miami-Dade counties. Mr. Codsey is a veteran trial lawyer with nearly 25 years of jury trial experience. He is also a two-time recipient of the South Florida Daily Business Review's Most Effective Lawyer Award, a recipient of numerous awards for providing pro bono legal services, and has been recognized by the National Law Council. Call our office, 786-464-0841 or 954-790-6711 and get informed. You're listening to Attorney Confidential with Gus and Neil. If you have a comment, question, or just want to contribute to the conversation, call the show at 888-565-1470 and share your thoughts on what's going on. Now, back to Gus and Neil for more Attorney Confidential.
And welcome back to Attorney Confidential with Gus and Neil. If you want to call in, it's 888-565-1470. You can also watch us live on Ustream.tv, and you can see our, matching. Neil, I'm starting to run out of shirts here.
I like the fact that you wore Carolina blue and I wore Duke blue, which makes me feel terrible.
I'm not sure this is Carolina
It's pretty
blue.
close.
So anyways, we've been talking about the court of public opinion.
Yep, smoke them if you got them.
Versus the court of law, which actually reminds me, I'm a big Mad Men, obviously follower, and last week we had the last show. But the first episode of Mad Men, he's trying to come up with a slogan or an idea for tobacco, for the cigarette industry. And this is around the time when you're not allowed to talk about the health benefits of cigarette smoking. So the picture that we had up there was It's Toasted. That's actually the slogan that Don Draper comes up with for the tobacco industry. So, but I know you can tell a whole host of war stories about the tobacco industry, but I think you have other things that you want to get into in the last 13 minutes of the show.
Before we do that, though, you had brought up the Bill Cosby situation. I wanted to give a shout out to our good friend Jeff Van Treese, whose show might be actually seated somewhere in our studio this morning. But he had one of the lawyers for that, one of the cases for Bill Cosby on his last show.
And which lawyer was that?
Jeff, which lawyer was that? Spencer Cooven. So,
that name sounds familiar. The University of Florida. I think so.
Is Spencer Cooven with Leopold Cooven? Was that the used to be? Yeah. Okay. Yeah,
that sounds familiar.
Yeah, I was at Carlton Field.
And so he represented Bill Cosby, or one of the victims.
Spencer Cooven represented one of the victims. I can tell you that. But very prominent plaintiff's lawyer. So
that's an interesting. Again, going back to the Cosby example, I think the idea is Cosby may actually never get tried, other than this defamation case. He may never get tried in a court of law because the statute of limitations is long since expired on practically almost all the cases, but the court of public opinion is going to try and convict him many times.
And a lot of times we talk about convict. When you talk about the court of public opinion versus the court of law, a lot of times you think of criminal cases, and Gus and I really don't. We know a lot of criminal lawyers, and we also know a lot of lawyers who practice criminal law.
Oh, I knew you were going to say that.
I was going there. But we don't practice criminal law. But that is usually when you think
criminal acts when we practice law.
Exactly.
There are a lot of cases. I think we were talking earlier about the BP oil spill case.
Right.
So, for instance, this past week there was a settlement announced between BP, Halliburton, and some of the other players. They've each brought cross claims against each other. It's funny because most people are not following the actual cases, but clearly that's a high-profile case. An example of a high-profile case where it didn't really take much. The court of public opinion, all those days of the oil spilling out into the Gulf.
Right. And look, and when you think of the court, I think we would be doing an injustice if we didn't bring up the obvious case. When you talk about the court of public opinion versus the court of law, and that's that case involving the hot beverage at a fast food restaurant. And if anybody needs to pause as long as they did to figure out my joke at the end, then you really don't follow. You shouldn't have to pause very long to know which one we're talking about. The McDonald's coffee case.
Yes.
And it's really interesting because when you dive into those facts, and when you really, and you can look this up on Wikipedia, but when If you actually look up the
Neil
facts,
already did.
Right. But if you look at the facts of that case, it really is egregious. I mean, McDonald's actually made a corporate decision to heat their coffee several degrees hotter than everybody else because they thought it would last longer. They had internal memos advising them that by making that decision, they were going to increase the possibility that anyone who spilled coffee could suffer serious third-degree burns. Memos going back saying, who cares? And you look at the evidence in that case and how it boils down, pardon the choice of words. I'm just full of fun. It's that Memorial Day weekend. Actually, the first weekend in 2 months I didn't do any work. So I'm back in relaxed form. I had my week last week. We talked about Monday, the deposition in Mandarin Chinese, a full week of depositions and a mediation in a case that didn't settle on Friday. And Saturday, I just went home and no work this weekend, so I'm much more relaxed. But go back to the McDonald's coffee case. I do think that's one where I think if you actually look at the evidence and you figure out what was given in that case, you're not as critical of the
I think
end
folks
result.
listening, just Google McDonald's coffee case and then put real story, right? Because I think your point is when most people think of the McDonald's coffee case, you think of, wow, someone got millions of dollars for spilling hot coffee on our lap. Really, we all know coffee's going to burn you when it spills on your lap, but I think in this case, your point is the company knew that the heat of this coffee was beyond normal, and I think it caused some severe injuries.
In fairness to the plaintiff, they tried to settle just for the medical bills. She did have serious third-degree burns because of their decision to heat the coffee several degrees hotter than anybody else and hotter than the industry standard, knowing what could happen.
Right.
And the lawyer offered to settle for just medical bills. And McDonald's took the position, heck no.
And that's
they paid for that decision.
Good point, because I think that's an example of where the court of law shows you the role that it should play, which is serve as sorry with the coffee pun, but a filter to the public, right? Most people would have said, oh, this is a BS case, this is a bogus case, don't give her a penny. But once you look at the evidence, you have an opportunity to present them in a fairly objective medium. You realize this is the kind of the courts did exactly what they should have done, which is penalize McDonald's for making an internal decision that they knew or should have known was going to cause some severe damage. Whereas most people would have looked at that set of facts and made an instant snap judgment without really looking at all of the evidence. And I think that's where the key distinction between court of law and the court of public opinion is, especially, whether it's criminal cases or civil cases. Most people's familiarity is with criminal cases.
Because what happens is 9 times out of 10, really probably 10 times out of 10, the juries either hear substantially more evidence than what the public hears.
Right.
Because the media decides which evidence they find interesting, or vice versa. The jury hears a lot less because some of the evidence that's played out in the media is not admissible in a court. Case I'm working on, the depositions I took last week where the client wanted me to go after this particular witness's criminal history and a lot of their background, the fact that they slept with a competitor's wife, and things that I know you're laughing because in deposition the jury will never hear it. Criminal history, you get to hear maybe a felony because the courts have determined that if someone has a felony conviction, a jury should hear that because it goes to whether they might be truthful. But misdemeanors and drug offenses that are felonies.
Why is that?
Because you're supposed to decide a case based on the relevant evidence of that case. Right. And just because someone has a bad past, it doesn't mean that this particular lawsuit that they're bringing lacks merit.
Correct.
And if a jury gets to hear about their bad past and that's all the jury's going to focus on, then even though this case might have merit, the jury might decide against them because they don't like the person.
One of the things we don't want to talk about here is politics, but for instance, sometimes high-profile cases nowadays, the in vogue thing to do is certain channels, certain networks, like a Fox, for instance, has their legal experts in there just completely taint the well.
Right, like MSNBC, I know. I think that's not giving away our views of certain sides.
But they'll completely taint the well, right, as far as all the facts. Right. And so people, the court of public opinion, will long since convict someone before the jury even hears the first charge.
I'll just say Keith Olbermann should have stayed on the ESPN. He wasn't even that good there, but boy, when you start thinking about politics.
Keith, you were fine. Dan Patrick, you made the right call. And now you got Bill Simmons, who's since moved on. So it seems to think, look, ESPN, if you're hiring, I'd be interested in going there and moving on.
I told my wife.
Would you turn down a job from MSNBC?
Yes.
No, you would not.
Okay.
Look at the camera.
No, but I'd be the token guy on the other side of the equation. But I told my wife once, if ESPN came calling, peanut butter and jelly for life would be fine. I would take that job.
So, look, there are a whole host of high-profile cases I think we can come up with. But again, like I mentioned earlier, there's some, just the regular kind of cases that, as lawyers, we have to look and see and think about at the very beginning, right? Because one of the things they teach you in law school, especially when you take trial court or any of these type of trial skills kind of cases, especially after you start trying cases, is prepare your closing argument at the beginning, right? If you take a case,
absolutely,
you actually do your closing and you think, how am I going to argue this in front of the jury? And so in doing that, you're thinking to yourself, how is the average Joe or average Jill is going to accept and going to take this case? And I think it's the same analogy. How is the court of public opinion going to receive my set of facts?
Exactly. You just have to base on the evidence that you know is going to actually come in at trial versus what the media portrays a case is so much different often than what the jury gets to hear and see.
But here's the important thing. You're not just trying cases, right? Because a lot of these cases we've talked about before, never see the courtroom, never see a jury. Yeah, you're going to settle them. Most of them going to resolve in advance. So a lot of the tactics that lawyers employ, using the media, using social media, for instance, is to try to put pressure on the other side. Because listen, bad publicity. I mean, especially when you're representing the victim.
Of course. If it's a high-profile case, you may settle it just for the publicity side of it. How many times do we advise clients that, as lawyers, these are the legal issues you're confronting? But you have a lot of other issues, whether it be a PR issue, whether it be a personal issue, whether it be, do you really want to go through this stress? So there's a lot of non-legal issues you have to take into account.
Do you really want to be the kind of company when someone logs into Google, and yes, we're going to use that log into Google thing every show if I'm here, when someone logs into Google and searches your company, and the first thing that comes up is this bad publicity. So anyways, we got a minute left. So, Neil, you got your 10, potentially 15-second takeaway.
Right. What I would just say is that there's a big difference sometimes between the court of public opinion and the court of law. And if you are a member of the public, which we all are, and you're not happy with how a case ends because of what you've heard in the media, you might want to take it a little bit further and find the transcripts, find what actually went on, because when you find what transpired, you might see that the court of public opinion is really a little bit in error.
Excellent. That was more than 50 seconds, but not too bad. I think now for the closing comments, we have a picture, hopefully it's going to come up here, of the deep thought of the day. Maybe. Yes, there it is. This is from Mark Twain, who said, "Life is short. Break the rules. Forgive quickly. Kiss slowly. Love truly. Laugh uncontrollably. And never regret anything that made you smile." Mark Twain. Happy Memorial Day. You're listening to Attorney Confidential with Gus and Neil. Tune again next week.
Good evening.
You have been listening to Attorney Confidential with Gus Bravo and Neil Kotze, two rated AV trial attorneys with over 40 years of experience. Tune in next week for another episode of entertainment, insight, and just plain fun. That's Monday, 6 p.m. on WNN, 1470 AM. See you next Monday for more Attorney Confidential. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.